Hello, and welcome to Construction Delays, what they are, why they matter, and how to measure them. A presentation by Austin Calhoun. I'm an attorney at Jimerson Cobb, a law firm in Florida, practicing general business litigation with a specialty in construction law. Here's the roadmap for our presentation, and we're going to start at the most basic level and work our way up to the most complicated aspect of a construction delay claim. At the beginning, we'll be at the basic level of what is a delay and the distinctions of different types of delay. Next, we'll look at a typical CPM construction schedule and go behind the curtain to look at the mathematics and logic that go into a schedule. Next, we'll examine why delays matter, basically time and money. Then we will endeavor to measure delays and look at the different analysis mechanisms that are available. Finally, we'll get to calculating damages and all the aspects that go into it. So what are construction delays? At the basic level, there's different nuanced distinctions. First, is the delay excusable or non-excusable? You then look at whether it's compensable or non-compensable. A delay is either critical or non-critical, and that makes all the difference. And then, is a delay a concurrent delay or non-concurrent delay? And we'll look at each one of these distinctions. First, an inexcusable delay. This is a delay that's caused by a party to the project. If you cause a delay, it's inexcusable. You're not going to be compensated for the delay. You're not going to get time, you're not going to get money. In fact, if you cause the delay, an inexcusable delay, you're likely subject to a delay claim, such as liquidated damages or an actual damages claim. Some examples of an inexcusable delay. This first one, that is an inexcusable delay. Some other ones, failure to manage the schedule, inadequate manpower, poor quality, poor safety. You can sum it up to poor performance. If your poor performance causes a delay, it will be an inexcusable delay. Excusable delays are those that are beyond your control. Someone else or something else caused it. As an example, a classic example, force majeure, such as acts of God, fires, floods. If the owner makes a substantial change to the project that causes a delay, that's excusable. Errors and omissions in the plans given to the contractor by the owner, if those errors and omissions cause a delay, that's an excusable delay for the contractor. Concealed, unforeseen conditions that cause delay are excusable, and most of the time intervention by outside agencies that cause delays will be excusable. For excusable delays, you're typically going to find that the contractor is at least entitled to additional time. It may not be entitled to additional costs. As we'll see later, it comes down to the contract terms. If a contractor causes an excusable delay, or in other words, an excusable delay occurs on the project, the owner won't be able to assess delay damages against the contractor. A delay claim is either compensable or non-compensable, and we're talking about money. Is the party going to have a money damages claim arising from that delay? Your typical non-compensable delay is the type of delay that was beyond the control of one of the parties. So going back to force majeure, acts of God, neither party caused that delay, so you'll typically find that those delay claims are non-compensable. On the other side of that coin, compensable delays, those where a party can seek damages, have some complicated facts that they have to prove to support that claim. And first, it was a delay caused by the party receiving the work. So if you're the contractor, the delay was caused by the owner. If you're a subcontractor trying to sue the contractor, the delay was caused either by the contractor or the owner. Next, you have to show that the delay actually impacted the critical path. As we'll see later, delays that don't delay the critical path have no effect. You then must show that the delay was a proximate cause of extra costs. So there's two prongs there. The delay had to be a cause of the costs, and then that the costs were extra costs that you would not otherwise have been incurred but for the delay. And finally, you must show that the delay was not in connection with delays caused by the claimant, the person bringing the delay claim. If they had any fault in causing the delay, will typically not be able to recover on the claim. This is a nifty flow chart explaining what we just talked about. Starting at the top, working your way to the bottom. At the bottom, where it says assess delay, that's your money damages delay claim. So first, was the delay excusable? If it was the type of delay that's a non-excusable delay, there will not be a claim for time or money. If the delay was excusable, is it the type of excusable delay that is compensable or is non-compensable? If it's compensable, then you've got a claim, likely for time and money. The contract between the parties is critical to a delay claim. When drafting or negotiating a contract, the parties should expect that there's going to be delays. In today's complicated construction context, delays are common, and they're best dealt with beforehand when the parties are negotiating the contract. What I mean by best dealt with in the contract is the insertion of certain claim mechanisms and clauses addressing what damages arise out of the delays and what delays are compensable or non-compensable. A contract can and should determine if certain types of delays will be compensable or not. For instance, going back to our force majeure, is an act of God or rain, even a rain delay, are those going to be compensable? Sometimes they should be, sometimes they shouldn't. Next, you look at damages, and are the damages for delay going to be limited in any way? The snippets of the contract on your screen are from a standard AIA contract, and the standard form AIA has a mutual waiver of consequential damages. That applies in a delay setting, a delay claim. So a party can't seek consequential damages arising from that delay claim. Without this type of clause, the party would be entitled to consequential damages. There's other types of damages that should be considered by the parties as well, and whether they will be able to attach to a delay claim or if the parties choose to waive them. Last but certainly not least is the claim procedure. It's often overlooked by the parties but certainly not overlooked by the courts. They enforce the claim procedures, and if not followed properly, it can completely bar a delay claim. The one on your screen on the bottom right, claim for additional time, it's a quite fair and balanced clause. All it requires is a written notice with an estimate of cost and probable effective delay. So there's no time constraint specified here, and that is something that should be considered by the parties and is found in some construction contracts. For example, you could limit the time to make a claim, such as something like 48 hours from the event giving rise to the delay claim. And a clause like that would be very onerous on the contractor and very favorable to the owner. Or moving downstream, if that's in a subcontract, that would be very favorable to the contractor. And it is enforceable. So why are we talking about delays? What do they matter? Well, to the owner, there's at least 3 areas of money damages that we see arising from construction delays. First, it's quite likely that the owner will be financing the construction project. If so, they're going to have interest and other carrying costs that they're paying on that construction financing. If the project is delayed, they're going to have to pay more interest and carrying costs. For example, if the project's 100 days long, they would only have to pay 100 days of interest. But if the project is delayed and takes 120 days, 120 minus 100, that's 20. That's an extra 20 days of interest and carrying costs that the owner is going to incur on their construction financing. In addition, something that's not thought about but probably relevant in today's increasing interest rate market is the permanent financing that will lock in interest rates once the project is complete. So if the project was to finish on time, it may end up with a lower interest rate on the permanent loan that the owner has to continue paying through the full maturity of that permanent loan. Second, and probably the most obvious, is loss of use or loss of income. The owner, let's say, for example, is a commercial landlord and is building a office building and it plans on renting out the space once it's complete. Well, that rental income would start to accrue once the building is complete, hypothetically, because the owner would get a tenant that would start paying rent. So if the project is delayed, that rent is being lost during that time of the delay. The loss of use is a little harder to quantify. It could be that the owner who intends to move in and use the building has to go somewhere else during the delay and pay rent somewhere else. That would be a good metric for loss of use damages. And then the third item would be an increased overhead or additional cost. These items are very fact specific to the project, but something to think about. Why do delays matter to the contractor? Well, for the same reason as they do to the owner, and as the old saying goes, time is money. There's different categories of damages for delay when we're talking about the contractor side. They're very familiar to some. On the screen we got direct costs, we got indirect cost. There's another category which we mentioned before, which is consequential damages. One example would be while the contractor is stuck on this delayed job, they're not able to go out and take those forces and work on another project that would be profitable and undelayed. So that lost profits is a consequential damages that can arise from a delay. The direct costs, very self-explanatory, the labor used to install and construct the project, the permanent materials actually incorporated into the project. So what does a delay have to do with that? Well, the cost of materials can rise. So had the contractor been able to purchase the materials as planned, they may have been able to purchase them at a lower price. Price escalation, material price escalation. Same for consumable materials, same for equipment. In addition, equipment costs, there's rental rates associated with equipment typically, and so the longer that equipment sits on the job, the more you got to pay for it. Indirect costs, a bit more challenging to prove when it comes to it. First, your extended job site overhead. That's the easier of the two. This is your on-site supervision, your trailers, etc. Often called general conditions, so extended general conditions. That's somewhat easy to quantify into a daily rate that can be applied to the number of days of delay. Unabsorbed home office overhead. It's a much tougher nut to crack, but it can be. And there's varying methodologies for calculating and proving up your unabsorbed home office overhead damages. The most common and widely accepted is what's known as the Eichle formula, rising from a federal case law. It's a very complicated area of the law, and there's too much to go into in this presentation. So we've been talking about delays, and you've got to understand the construction schedule if you want to understand measuring delays. The key terms involved in construction scheduling would start with the activity. That's the item of work that is being performed. On the right side of your screen, you see a representative portion of a typical construction contract schedule, and the activities would be each line item, each row. And for the activities, there's a certain logic or relationship interweaving between activities. There's predecessor and successor activities. This is best described, by examples. So if your activity is foundation, installing a foundation, and then another activity is installing a wall that sits on top of that foundation, the foundation has to be installed first, then the wall can be installed. So the foundation is the predecessor, the wall is the successor. And for each predecessor-successor relationship, there's different types. On the screen you see FS, SS. FS stands for finish start. SS stands for start. A finish start relationship would be the type that we just talked about, the foundation and the wall sitting on top of it. The first item, here the foundation, has to finish before the second item can start. With a start, it's two items that need to start at the same time. There's other categories such as finish, which is two items that need to finish at the same time. So this logic or relationship between the activities is critical and is what really builds the schedule. In today's day and age, schedules are created using software, and we input data into that software. You start by listing out all the activities, and then you have to put logic and relationships between those activities. And it's those logic and relationships that really determine the schedule based on the duration of the activities. That's duration's rather self-explanatory. It's the number of days that it will take to complete that activity. The critical nuance here is, what type of day is it? Is it a business day or is it a calendar day? It makes a big difference. The schedule should define that. If it doesn't define it, what is it? Is it a business day or a calendar day? And that matters because, let's say a duration is 15 days. Well, 15 days can be, if it's business days, that's 3 weeks, because you're not working on the weekends. If it's calendar days, then it's 2 weeks in 1 day. Another thing to think about is, are you working weekends? Are you working holidays? Those need to be reflected in the logic of the schedule. Otherwise, it's going to skew your finish date. Critical path is, pardon the pun, critical. We go into detail on that coming up. Critical path is the only part of the schedule that matters. If there's a delay to the critical path, you may have a claim. If your delay is not to the critical path, there is no claim. Float, we'll save that for a minute, and we'll come to that. As planned and as built. As planned is at the beginning of the project. It's the original schedule. It's how the project is supposed to be built, and it's the obligations of the parties. It's the rights. What rights do the parties have to that schedule? As built is what actually happened. This is an example of one of the typical softwares that are used in the construction industry for construction scheduling. It's not the best, most clear example, but what this is, a Primavera project planner, or P3, and it's just shown to give you some familiarity of what to look for. And again, it's not very clear, but some of the information that's important here are so we have your activity. Each line is an activity, and that's the name that describes it. And then you have columns, and ordinarily your first column is going to be the original duration. That's your as planned duration. That's where the parties' rights arise from that duration. Next, you'll typically have actual duration, which is where you can come in and provide updates as the project progresses. How long did it actually take? Then you've got the start date, finish date, and then there's this line in between the tabular information and the graphical information. And I point that out because when you're in the software, you can slide that over, or in other words, you can add more columns. The columns could be in there and just may not be shown on what this print view is, but there's some critical information that's not showing up on this printed schedule. For instance, we talked about the logic or the relationship between the activities. That's critical information when you're, at the end of the day performing an analysis to determine the delay. And you can't tell with very much certainty what the relationships are here, but you can add a column that will very clearly show you what the logic is that this schedule is based on. In this P3 example, there are lines that you can see, for example, between these activities, and those do indicate roughly the logic between those activities. Also want to point out that normally these bars that are in red, that's indicative that those activities are the critical path. The items in green are not in the critical path. And another piece of information that's not shown here is the number of days of float. This is just another example of a different type of software that can be used for construction schedules. This is Microsoft Project. In essence, it's the same as the P3 that we just looked at. You've got activities listed by row with columns of information. And here you see we were talking about the logic that did not show up in the printed schedule in the previous slide, and here it does. So now when we endeavor into our delay analysis, this critical information that the delay expert requires is shown. He's not having to make an educated guess. The types of schedules that are common today, and the ones that the courts are the most fond of and put the most weight in, is the critical path method, or CPM schedule. The two examples that we looked at on the previous slides are examples of a CPM schedule. And there's a very mathematical underpinning to these schedules. This graphic is representative of the mathematical analysis that is behind the scenes of the construction schedule when you're looking at it in P3 or project. Before the computer age and the softwares that are used today, this is how schedules were calculated. So it's and that's just what the software does. This is the same calculation that the software has to go through and in some fashion represents in the Gantt chart that the softwares produce. So each block is representative of one activity. In this block, it's activity Q. Activity Q has an original duration of 18 days. It takes 18 days to complete activity Q. On the left two blocks, we see the start dates. To the right is the finish dates. So the early start, which is the top left block, is, this shows 0, which means, day 1. The below that is the late start. And what is the difference? Early start, late start. Well, it has to do with float. So if we come down to this activity here, we see at the top for activity T, we see TF equals 20, that total float equals 20. Well, this is one path. That path has 20 days of float. And this activity, being on that path, has 20 days of float. So it can start on day 1. That's the earliest it can start. The latest it can start without delaying the schedule is day 20. On the right side, you got your finish dates, your early finish, and late finish. The arrows are representative of the logic between the activities. For example, this between Q and R, this arrow is a finish start. It connects to the finish side of the block and connects to the start side of the R block. The critical path is of the utmost importance to a construction delay because it's only delays to the critical path that delay project completion. And it's project completion that's at the heart of a delay claim, especially between the general contractor and the owner. So an understanding of the critical path is mandatory. If a delay does not affect the critical path, it's not likely to be compensable, and either with money. Could be compensable with time if that activity is still ongoing. Let's go back and look at the slide we were just looking at. And let's look at our old-fashioned schedule, because it really kind of highlights the concept of critical path. So here on this project we have three paths. We have the top path, which is QRS, the middle path, TUVW, and then the bottom path, which is X. Each is a path. The top path takes 40 days. Well, it's Q is 18, R is 12, S is 10. You add those up, that's 40. I will point out that there could be some built-in delay in between the finish and the start of these activities that would make that longer, but here there is not. If there was, you would see that logic delay represented in between these boxes. So we know that there's 40 days to complete this path. If we come down to the bottom, X is the only activity on this path. It's 10 days in duration, so this path is only 10 days long. In the middle, if you add up these days, these durations, it totals 20 days. So we know that the critical path, being the one that is the longest path, is currently this top path, Q, R, and S. These are the three activities on the critical path. A delay to Q, R, or S will be a delay to the critical path and necessarily delay. Concurrent delay is another term or concept that needs to be understood, as it does have an effect on the delay claim analysis. Concurrent delays means two delays occurring at the same time. So they're separate, but they're occurring at the same time. So it's if activity A and activity B are going on at the same time and they're both being delayed, those are concurrent delays. What's important there is one may be critical and one may not. The graphic at the bottom right corner of the screen shows this concept pretty clearly, so we should walk through it. We've got two paths on this schedule. We have path A and we got path B. Path A is 40 days in planned duration. Path B is 30 days in planned duration. Path A, being the longer path, is the critical path. The project begins, and 5 days into it, both paths start to be delayed. Path A is delayed 5 days, but Path B is delayed even longer. Path B is delayed 10 days. So you would maybe naturally assume that that 10-day delay of Path B is critical. But what we'll find out is that it's not. So the 5 days delay in Path A pushed Path A out to 45 days in total duration. So Path A is still, even after the delays, the longest path. Therefore, Path A is still the critical path. So the 5-day delay to Path A, that's the critical delay. The concurrently occurring 10-day delay to Path B is non-critical. now we turn to float. We mentioned float before, so we won't spend much time with it. But it's the difference between when an activity can start and when it must start, so that the project won't be delayed. If an activity has no float, it's probably because it's on the critical path. Not necessarily. There are certain mechanisms in today's software, such as constraints, where you can force something to start on a certain date. It'll show up as no float because it has to start on that day, but it may not be on the critical path. And float, there's an issue of who owns it, who's got the right to use up that float. And if it's an important issue to you, you need to put it into the contract. Because if you don't write into the contract of who owns the float, well, then it's ambiguously owned by the project, and you don't. So that means one party doesn't have a right to it. Looking back at our old-fashioned graphic here, we can use it to better understand the concept of why you would care if you own the float, and what does it mean to own the float. Well, this our middle path, which is made up of 4 activities, in total has 20 days of float. So in theory, each activity has 20 days of float associated with it. It shows 20 days of float for that activity. For here in T's got the early start of 0, the late start of 20, therefore it's got a total float of 20. Well, that same float is showing up on all 4 activities. So what happens if T uses up all the float? So what if T it decides that it doesn't want to start right away, it wants to go out and do some other projects in the meantime. It's going to show up and start on day 20. Well, what does that do to the successor activities? It takes away their float. It eats it all up. Because if T doesn't start until the early start of 20, then it won't finish till the late finish of 24. And 24 is the early start, the late start for you. All the float will be gone. So now U, V, and W, which previously had a nice 20-day float buffer between them and a critical path delay claim, now they're on the critical path. So U, V, and W, if they delay it 1 day, they're delaying the critical path. So now U, V, and W are subject to or put in a much riskier scheduling position. So amongst T, U, V, and W, who owns that float? And if T delays 20 days and uses up all the float, do U, V, and W have a claim against T? Because but for T using up all that float, they wouldn't have been on the critical path, and then their delay wouldn't have been a compensable critical delay. So there is the argument, and without addressing that clearly in the contract documents, the answer is, we touched on as planned and as built previously in the presentation. As planned schedules, that's the contract schedule. That's what the project was started upon. And the importance there is it's like the baseline. It's what sets the parties' rights. And all claims are compared to that as planned schedule. Then when you're done, when it comes time to make a delay claim, you've got an as-built schedule that needs to be created, or if there may have been one created by periodic updates throughout the project, which is good practice. So hopefully there is one, but there's not always. And the comparison of the as-built to the as-planned schedule shows you your delay. We're getting into soon the different analysis methodologies for analyzing a delay claim. And one critical piece is the information that the analyst, that the expert has at its disposal to perform that analysis. And the more, the better, the clearer information that the analyst has, the more accurate, more credible, and useful the analysis will be. Ideally, there's all of these things that have good, clear information on what really happened on a day-by-day basis as it applies to the schedule. So we have our as-planned schedule, and hopefully it was updated periodically, monthly at a minimum. In the project daily reports, every day is talking about which trades are working where, what are they doing, if there's any delays, they're highlighted. The meeting minutes need to discuss the schedule in every meeting, and if anyone is delaying the schedule, if anyone needs a change in the schedule. Then any reports could have information that identifies in a snapshot of time what was going on that day, so that the analyst will be able to plug that information into his analysis if he doesn't already, otherwise have it. Correspondence and other memos to file would also be helpful. Definitely cannot have too much good information regarding the schedule updates. They'll be critical to the viability of your delay claim because they are the lifeblood of the expert's ability to analyze the delay. And these are our different approaches, and they're not all created equal. At top, we list out 5 different analysis approaches, and these top 3, we don't recommend. And the reason why is that the courts place little weight in these analysis. So when it comes time to prove your delay claim at trial, is the court going to place any weight? Is that analysis going to carry the day with the court? Are they going to even allow it into evidence? If it's not reliable, maybe not. And these top 3 have been at times not used, not allowed by courts. The best method as far as litigation goes is your contemporaneous schedule analysis. We also highlight here, and we'll briefly touch on later, a time impact analysis or FRAGNet. That is not an after-the-fact analysis. That's more of a prospective analysis done during the project at the time or prior to a delay arising. At the bottom half of the screen, we've got a table. It uses different names for the analysis, but in essence is the same, and it goes from worst at top to best at bottom. And the accuracy expected is critical if you have to litigate your claim. Like I said before, these methods here are less reliable in court. Your best bet, if you want to ensure the success of your claim, that the courts will find favorable, is this contemporaneous analysis. But what's critical for to understand is this: the data required, and it's not just quantity but also quality. Also, what's important is this: So a good contemporaneous analysis of a 2-year schedule, maybe it could be $50,000 easily, depending upon your expert. These lower tier methods will cost less. They require less data, but the output is poor. But if you don't have the data that you require to do these better methods, you may be stuck with one of these lesser methods, which could end up in less than excellent results at trial. We're going to look at each method a little bit. We could spend a lot of time on each method. Each one, to fully flesh out, needs probably an hour or so, but we'll just kind of highlight here. So the impacted as planned analysis starts with the actual as planned schedule, the contract schedule, and then you deal with impacts. And impacts are what's alleged by one of the parties. So one of the parties thinks there was a delay of some cause. Here it says owner's alleged impacts. But if we want to come up with a easier to understand example, maybe we could call this a contractors alleging that this was a rain delay, 10 days of rain. So on day 2 to day 12 it rained. And so under this analysis you cut and paste the 10 days of delay directly into the as planned schedule. You at the day 2 you cut A and move A over. And that's called the impacted schedule. And you compare, once you got the impacted schedule, you compare that to the as planned schedule. And you see, compared to the as planned, there's an extra 10 days of delay. So if you're using this as your analysis to prove your delay claim, sure, yeah, I mean it shows what you want. This is what what you're trying to prove is 10 days, but is it accurate? Can it be relied upon? And the answer is no. And here's a great example on this at the bottom here of what really happened on this hypothetical project. And what was the true delay was only a 5 days of delay to the critical path. And so what really happened was, while this rain was going on, activity B was still able to work. And so when the rain stopped and A was able to finish, C didn't have to wait on B anymore. So that sped up completion of the project. And this is just indicative of the two major weaknesses to this analysis method, and that's it in no way addresses shifts in the critical path. So it takes the as planned, what the critical path was intended to be on day 1, and that's the path that it uses. Well, throughout a project, as sequencing may change, as some intermittent delays may happen, as means and methods may change. All these different things can affect the critical path, and quite often the critical path will shift into other activities. Just because activity B, C, and D were originally planned to be critical path, that doesn't mean that they're always going to be on the critical path. Halfway through the project, maybe the critical path changes to some other, maybe it's E, F, and G that turned into the critical path halfway through. So this analysis method doesn't address that in any way. Also, it doesn't address out of sequence work. This example down here at the bottom where B was able to, in actuality, be performed out of sequence, and the impacted schedule can't address that. And that's a fatal flaw. So a little bit better than the prior analysis method is the collapsed as-built analysis. And here the starting point is not the as-planned schedule. Your starting point is an as-built schedule. It's an as-built schedule built by the analyst using the best data that he can find. If he's got wonderful data that shows all the logic between the activities and shows the actual durations of all the activities, he may be able to create a pretty decent as-built schedule that fairly represents what actually happened on the project. But on many times he doesn't have all the information that he needs, so he's got to make some guesses. And it's because he's got to make some guesses, maybe educated guesses, but still speculation, that erodes the reliability of the analysis, and the courts understand that, and they weigh it accordingly. A court, under this collapsed as-built analysis, may refuse to entertain the results of the analysis unless it feels confident that the speculations, the guesses that the analyst took to create the as-built were fair and reasonable and based on sufficient documentation. So once that as-built is created, then we're back to isolating our impacts in the schedule. So this is different than the prior method where we actually cut and paste the impacts into it. Here, when you're creating the as-built, the impact is within that duration. So the job here is to identify the start and the end of that impact. Not easy to do, but with good enough information, it can be done. For instance, if it was a lack of manpower that caused A to be delayed, well, if the daily reports reflect the daily manpower for subcontractor A, then this as-built with impacts can be accurately reflective of when the manpower was too low, which was the cause of this delay. Once you build this as-built with impacts, now we got to collapse it. And what we do here is you pull out the impacts. So you take this impact one and you pull it out, and then so this part of A shifts back to here, and that's what you see here. You see the impacts taken out of C, you see the impacts taken out of D. And, well, that's a good point. D, you don't have to take the impact out of because it's not on the critical path. If you see the critical path is traveling through C directly to E, it doesn't pass through D in this as-built with impacts. So impact 3 is not a critical delay. So it does show that, whereas the prior analysis may not. But once you collapse the as-built schedule, you then measure that against the as-built schedule, and the amount that it is shortened is actually your amount of delay. We come to what most consider the best method, the most reliable, certainly what the courts prefer, and that's the contemporaneous schedule analysis. There's a variant of this methodology called the windows analysis. They're slightly different, and it's just too much to get into in this short presentation. We could go on and on. We could do an entire presentation just on contemporaneous schedule analysis. But why is it the best? Well, look at the analysis that it does. It's based on current project schedules. It's not schedules that were created after the delay. All the other analysis methodologies that we went through today require the analyst to add some subjectivity. He's got to take steps to create one of the schedules used, either the as planned or the as built schedule that was used in the analysis. And that courts don't like that. It erodes the reliability when the analyst, who's naturally biased, has a role to play in the creation of the schedule that the analysis was based on. So here, another benefit is it takes into account shifts in the critical path, which because a delay to the critical path is all that matters, you need to, or a good analysis must show you if the delay was on the critical path or not. And the reality is that the critical path is likely to shift throughout the project. It identifies the delay attributable to a specific issue or specific activity, and it gives accurate representations of the perceptions regarding the critical path. And just real quickly on how this analysis is performed. Of course, it starts with the as-planned schedule, which is the contract schedule. That's the baseline. And then it doesn't create an as-built schedule. It uses the as-built schedules that were created during the project. So one necessary piece of information that this analysis methodology requires is that there were schedule updates throughout the project, and the schedule updates need to show sufficient information to allow that schedule analyst to perform this analysis. So it right there just goes to show that if you want to preserve your delay claim rights, you better be updating your schedule, updating it correctly, and accurately or adequately saving that information such that it can be given to the analyst after the project. Also, on top of using the as-built schedules, periodic updates, etc., it uses facts gleaned from other sources. It uses any logs, it uses daily reports, it uses meeting minutes. The more information you can give to the analyst, the better this analysis is going to be. And then on the bottom right, there's a graphic that shows a summary of the delays. So it actually gives you a side-by-side comparison of each activity. And if you recall from the other slides, the other methodologies did not compare it in that way. It did not do a activity-to-activity comparison. In this way, we can attribute delay to the responsible activities, to the responsible party, which, as we'll talk about in a second, is critical. And you may not have a claim at all if you can't properly attribute or allocate the delay. Finally, our last analysis to look at is the time impact analysis. There is a retrospective time impact analysis that can be done, but we just want to point out the prospective, and that is done during the project, before a change is executed, or at the moment that a delay event occurs, and you build that into the schedule at that time, and you make what's called a fragnet, which shows the added work or shows the delay event and how it ties into the existing CPM schedule. Of course, the analyst, or very likely, and what I would suggest, the project team, the builder, whoever's responsible for the schedule on the project, should be doing this, and they obviously need to use reasonable logic and durations, but who better to do that than the contractor at the time. So you add the fragnet to the CPM when the work was ordered or when it began, and the schedule update is recalculated to see if the completion date changes. So you'll know at that time what effect that particular change or event, that impact, has on the project completion on the critical path. So we've just spent a lot of time talking about the different delay analysis mechanisms. Well, once you've gone through that analysis, the results are a number of days. It just tells you the number of days of delay. That's really just the first step in a delay claim. Now you got to convert that day into money, and that is what we turn to now, calculating damages. The screen is filled with a bunch of hyperlinks to blog posts. Our firm did a series on this topic. It's very informative, and I would suggest that if you're looking for more information at this time or in the future, if you want to come back and learn more about delay damages, this should be your first stop. So we calculated in the number of days of delay, and in some of the less preferred methods, it just gives you one number. It gives you the project delay, overall project delay. Well, it's not reasonable to presume that the one party you're making a claim against was solely responsible for that and for all of that delay. Construction projects are complex with a lot of people, a lot of moving parts, a lot of things, and everybody has a duty, and it's most realistic that for any delay, not just one party is solely responsible for it, that other parties caused some form, some measure of delay on the project. And courts understand that, and there's a firm rule in the courts that if you can't account for and attribute delay to the responsible parties other than the party you're going after, then it's not reasonable for you to have recover on your claim. That you can't. In other words, you will not recover on your delay claim unless you can reasonably allocate and apportion responsibility to the parties. And that's a bit of a mouthful, but using the contemporaneous analysis, it makes it really simple. And because it compares activity to activity. So if activity X was delayed, and when it was delayed it was on the critical path, for each day of delay for that activity that it was on the critical path, That's a day of delay that can be attributed to that activity, and to whoever is responsible for that activity. For example, here, we've got, this is the entire project, and throughout the project, these are the items that were on the critical path as the project progressed. And over here you see if there was delay or improvement. For instance, in the rough grading, they made up 3 days, so they got a good start. The schedule was 3 days ahead. Then when it turned to the foundation and tunnel form work, which it became the critical path, those activities caused 74 days of delay. So under this contemporaneous analysis, you necessarily can show that 74 days out of the total 349 days are properly apportioned to the foundation contractor. So if you decide to pursue a claim against the foundation contractor, you can meet your burden of proof here in that it is responsible for 74 days of delay. If you were to make a claim for 349 days against the foundation contractor, you can see why a court would hesitate to award you anything on that claim if you weren't able to show any apportionment. If you said he's responsible for all 349 days and nobody else is responsible for anything, it's just the foundation sub. Courts don't take to that, and if you're not able to apportion responsibility for delays, you will not succeed. It's all about the contract. Don't forget about the contract. So we've figured out how many days there were of delay. We apportion them to the responsible party. Now we pull out that party's contract and read it to see what effect it has on the claim. First, what's the claim mechanism? Was the claim mechanism followed? If there was a limited amount of time to make a delay claim, was the claim made within that time? Was the claim made in a writing that meets the specificity requirements of the contract? A contract can say that a claim must be made by written notice that adequately describes X, Y, and Z. Well, go back, pull out the file, let's look at the documents. Did you do that? If not, you may not have a claim, because the courts do enforce these, claim mechanisms, even if they seem harsh. Unless you can show that by the course of performance of the parties there was a waiver of that requirement. Then we look to see if delays are compensable or not. If delays are not compensable, you don't have a claim. What type of delays are compensable? Is that the type of delay that we have here? And then we look at damages limitations. Again, in the AIA, there's a mutual waiver of consequential damages. So when we start to, which is our next step, start adding up our costs that we can seek as damages, can we add consequential damages onto that? Or, is there other damages limitations? So because we can only seek, or should only seek, the damages that you're entitled to. Just as with the schedule analysis methodologies that we looked at, there's numerous methodologies for calculating damages attributable to delay. Some are better than others. Here we've got a list of 4 of them. They're the most common. We're going to look at each of them. You got liquidated damages, which isn't well, it is a methodology for calculating damages, but it's a little different than the others, as you probably know. There's the total cost method, modified total cost method, and jury verdict method. We'll look at each. Liquidated damages is a concept that can be written into the contract, and it is designed to replace actual damages. So it is a methodology to calculate, or at least provide a way to easily calculate damages. Keep in mind that proving actual damages is a momentous task. It takes hours and hours of document review and intensive fact searching, and quite a high burden in having to prove that at trial. Not to mention the fact that you'll most likely have to engage an expert witness to review all the documents that are related to cost and provide an analysis and then testify to the court. All that can be avoided by a good liquidated damages provision, and that's really the concept. Some contractors and subcontractors have a natural aversion to it. They think, ooh, liquidated damages, no, I won't accept it. Well, if they understand it, then they can see it as a benefit. If negotiated properly, it can be quite a boon. They can dramatically limit their damages. Not to mention all the cost savings in the event that they have to litigate a delay, because proving up actual damages in a typical construction lawsuit can easily add $50,000 or more in legal fees and expert fees. So that being said, courts will enforce a well-written liquidated damages provision. However, they will not enforce it if it is considered a penalty. If it's a penalty or otherwise unconscionable and unenforceable, then you're back to actual damages. You're back to having to prove up by one of these other methodologies that we're going to cover what your actual damages were. The three factors set forth in Florida case law on whether a liquidated damages is a penalty are shown on your screen. But really the key here is that the amount is commercially reasonable, or reasonably related to what the parties could predict the actual damages would be. A better way to understand that is maybe by way of example, to put it in perspective. And if you got an owner who's building an office building to rent out, and the rent is, in his pro forma, at least when he's deciding to go forward with the project, he hopes to have a net income of $10,000. And so that, if you do the math to reduce that down to a daily rate, that's from $10,000 a month, that's approximately $333 a day. So without considering any of the other owner damages, which you would want to, such as increased interest and carrying costs and maybe additional direct cost, you can see that $333 a day would be a reasonable amount for liquidated damages. Because if the owner has to sue for a delay claim to seek actual damages, the lost rent is going to be an actual damage, in addition to all these other items that the owner's lawyers are sure to tack on to the lawsuit and seek. So, and maybe, we don't know, maybe the rent market could increase over time, or maybe the owner could negotiate a really good rent after the fact, and it reflects a $20,000 a month metric to prove up the actual damages. I say all that just to say $333 a day in liquidated damages is a fair representation of what the parties foresaw as potential actual damages. So that would be a good starting point for negotiating liquidated damages. If the contractor could get it down to $250 a day, great. But if the owner comes in and claims $4,000, $5,000 a day in that scenario, that's not very related, reasonably related to what is expected to be the actual damages. So in that scenario, a $5,000 a day liquidated damages amount is, could be found a penalty. Then the courts wouldn't enforce it. Turning now to the actual damages, if you're in a case where you have to prove up your actual damages, what's traditionally called the total cost method, it's less reliable. It's not what courts like to see, and they're only going to give it any degree of weight if there's no other means, more accurate means of determining damages. So, put it simply, the method is you take your actual costs that were incurred and you subtract your original estimate of costs. The difference is the damages. So, by way of example, you had a contract for $1 million, part of that being profit. Your cost that you originally estimated were $800,000. And if you would have performed the contract and there would have been no delay, that's what you estimated the amount of cost you would have incurred throughout the project. However, the project was delayed and you ended up spending $1.2 million, so $400,000 more than what you estimated. That would be your total cost method approach. So what are the weaknesses there? Well, if we look at what the courts, what tests the courts apply, it kind of is a good way to look at the weaknesses. So the first test is that the original bid or estimate was reasonable. Well, gosh, think about what you got to do to prove whether your original bid or estimate was reasonable. It's not unheard of for a bid, a busted bid, for a contractor or a subcontractor to take on a job based on a bid, and they end up losing their shirt because they after the fact realize they missed something, and what they thought was going to be an $800,000 job ended up costing them $1 million because they missed it in their bid. So for that reason, this method is frowned upon, and the courts are critical of it. Then you turn to the next three factors, which are pretty common to all the methods, and that is the amounts expended by the claimant for the additional work were reasonable, that your actual costs were reasonable. And then any excess amounts were due to the defendants, that whoever you're bringing the delay claim against caused the delay, and those in that delay that they caused those costs. The last damages calculation methodology we're looking at is the modified total cost method. It's generally accepted by the courts, and in essence it's a compromise between the total cost method and actual cost data, where you segregate specific damages to specific instances. If the actual cost can be accurately determined, then that's the best approach. But you're going to use these other methodologies when you can't accurately prove up the actual cost. This modified total cost addresses a couple of the shortfalls of the total cost method. It addresses the reliance on the claimant's estimate. It makes adjustments to that estimate to bring it in line with what's reasonable. So, for instance, you could look at the claimant's price in comparison to all the other bids. If it was in line with all the other bids, then the price is probably reasonable and doesn't need to be adjusted. But if the price was 20% lower than the next the next bidder, you probably, to make it reasonable, it probably needs to be adjusted. The estimate seems like it may not have reasonably reflected a reasonable estimate, so we need to raise it. This also looks at the fact that the claimant probably has some role to play in the delay, or not maybe in the delay, but in the extra costs. So it subtracts out the extra costs that are attributable to the claimant, and then it also, lastly, it subtracts out costs of additional work not attributable to the other party. If it's the general contractor, if there was additional work not attributable to the owner, if the general contractor is suing the owner, there's no reason that needs to be in there, so you take that out. So, all that together is what sometimes called the equitable adjustment, which is the difference in the modified total cost method and the total cost method. The elements that are necessary, at least under Florida law, are that the original bid was reasonable, the costs expended to perform the additional work are reasonable, and that the claimant was not responsible for the additional cost. But the equitable adjustment addressed. Then the jury verdict method. This is what applies if you can't prove it up with actual damages, and there's no methodology that's reliable. So there's definitely clear proof that an injury exists. We've got that, but there's just not a lot of evidence. But there's some evidence, and it's sufficient to make a fair and reasonable approximation. So the thing here is, we can't accurately determine the amount of damages. So court, jury, we need you to approximate the damages. We think there's enough evidence for you to make an approximation. We know we were hurt, so we need something, or do something. We can't tell you exactly what it is. You tell us. If there's a more exact method, the jury verdict method will not be used, but it has been and continues to be employed in the right case. Nearing the end, just want to leave you with a few things. Here, checklist. It's in the case of a delay claim. Refer back to this. Look at these are the types of costs you need to be out there looking for, pulling information on, including in your claim. No need to go through these now. Just wanted to give it to you for your future use. And last, but certainly not least, some proactive advice. These are the things that contractors or subcontractors should be implementing in their projects to shore up their potential for claims. In the event that someone does cause them delay, that they'll be able to succeed in their delay claim, which is really important because delay claims can be quite costly to pursue in legal fees and expert fees. So you don't want to pursue a claim, expend all the fees, and then lose because you just didn't. You knew you were right, but you just didn't have the evidence. You didn't have the best information to do the best analysis. You were stuck. You didn't have enough information to do a contemporaneous delay analysis, so you were stuck doing one of the lesser approaches. And the court said, no, we're not going to give any weight. We're not going to give credibility to that report because it's just too unreliable. So here's some advice. Create a CPM schedule, a detailed CPM schedule broken down to the smallest activity that you can. Put the real, build it in with the real logic, the most true to life logic relationships, and incorporate that into the contracts. Involve all the parties in the development of the schedule. Before I became an attorney, I practiced in the construction industry for 8 years and did a lot of scheduling myself, and found this to be very valuable. We'd take all the key players, all the key trades, owners, subcontractors, suppliers, get them all in a room, and we'd go through the schedule together and make sure that everyone was on board, and that these people that are more intimately familiar with the intricacies of their scope can look, examine the schedule and tell us that it's accurate and fix it if it's not. Because you want your as-planned schedule to be realistic. And a general contractor creating a schedule for a project in a bubble without outside input may not be realistic. Next, establish systems to ensure that the schedule is updated accurately. Need to be routinely updating the schedules. In addition to making it routine, you need to make it accurate. So how are you getting the information from the field routinely that's accurate and getting that into the schedule update? Integrate the schedule into the day-to-day operation of the project. You invest time into the schedule, you get buy-in from everyone for the schedule, you use the schedule. It's a part of the day-to-day operations. The superintendents, the foremen, the trades, everyone's using it, looking at it at a daily basis. Integrate the schedule review into project meetings, whether this is a daily meeting at the field, a weekly meeting, a monthly meeting. No matter who's involved, make one of the agenda items schedule review, and keep good minutes of every meeting. Every time you're discussing the schedule, keep good minutes. That's going to be good factual evidence to supplement the contemporaneous schedule analysis. Act immediately to halt any delay and look for ways to mitigate your damages while it's still possible. As soon as you identify a delay, put a fragment in the schedule, and then make sure you accurately report status of activities, if incomplete, as of update, to allow detection of inefficiency or productivity issues. Thank you for your time. I hope this presentation was valuable, and I'd like to give thanks to our law clerk, Frankie Velez from the University of Florida, who was a big help putting this presentation together and overcoming my personal delay in getting it done. I'd also like to thank Troner Consulting Services, who's a scheduling expert that we've used in the past, and they do a great job. Thank you again, and if you ever have any questions about this topic or any other construction or business law related topic, feel free to call us and for some advice. Thank you.